My name is Leonard Leo, and I serve as Executive Vice President of the Federalist Society. It is a privilege for me to welcome all of you to this year's National Convention. It's heartwarming to see so many familiar faces, but it's also exciting to welcome a number of newcomers to today's gathering. We come together here in Washington, D.C. each year for a number of different reasons. Perhaps to meet up with old friends, perhaps to obtain information about the state of our legal order and the public policy world from an array of opinion leaders with diverse perspectives, and perhaps to search out ways of becoming more involved in the Federalist Society as well as the public square more broadly. I would like to suggest, however, that there is another common objective that should bring us together, and that is to spark and sustain a thoughtful national conversation about whether our culture remains truly committed to limited constitutional government, and if so, how best to keep it that way. Now, the objects of this conversation will vary from time to time, with much of the focus this year being on the federal government's economic role in our constitutional system. And, as you all know, the conversation will inevitably involve the airing of quite a number of different and sometimes irreconcilable perspectives. This convention will be no different than those from previous years in this respect. But this conversation is important and worth having in any event. Now, I'm not prone to invoking Ralph Waldo Emerson, but I do think he got it right when he said that wise, cultivated, genial conversation is the last flower of civilization. Conversation is our account of ourselves. It is, in a word, how we search for and discover the truth. And truth, that which is right and just, ultimately is what propels us to work as engaged citizens in ways that have real, tangible impact on the future direction of our republic. So we begin the conversation this morning with opening remarks by United States Senator Jeff Sessions of Alabama, who currently serves as the ranking member of the Committee on the Judiciary. Senator Sessions, of course, is no stranger to the Federalist Society, having actively participated in its work going back to the 1980s and 1990s when he served as a United States Attorney and then as Attorney General of the state of Alabama. He has, in the United States Senate, distinguished himself as a committed originalist, seeking to undertake the enterprise of legislating with a deep regard for the Constitution as it is written and as it was understood by the Founding Fathers. We are privileged to have you here today, Senator, to start our morning with remarks about the third branch of government, whose jurisprudence obviously affects much else that we will be examining these next several days. Ladies and gentlemen, please join me in welcoming Senator Jeff Sessions.
Thank you. Thank you very much. It is truly an honor for me to participating in kicking off this 2009 Lawyers Convention. And let me say how much I appreciate Leonard Leo and his leadership and all of the team at the Federalist Society for the great contribution you make to the discussion of the law in America today, and I think it's critically important. Federalist Society are wonderful advocates for the great legal concepts that we all value. And Leonard, I particularly appreciate you and your friendship and insight into the key issues of America. And I do remember the founding of the Society in 1982, and since that time you've served as a bulwark for the defense of the timeless principles of freedom, of objective law, judicial restraint, separation of powers, and ordered liberty. You recognize that a sound legal philosophy, objectively executed, is the source of our freedom and prosperity. I remember during the Sotomayor hearings, she had made a speech in which she quoted, and she's a fine person and in many ways just a quality person, but she made a speech in which she said about law and the difficulty of judging. She says, there's no objectivity, just a series of perspectives. And that still makes hair stand up on the back of my neck, I got to tell you. The Federalist Society's leadership and its defense of our Constitution are more critical now than ever before, and we just cannot let up. I hope that you'll leave this conference with a renewed passion for defending the great heritage of law that our forefathers have blessed us with. It's certainly a pleasure for me to be here to share with you some of my thoughts, for what they're worth, on the challenges that we face. I'd like to begin by telling 3 short stories. Inside the Indiana General Assembly, the Speaker of the House prepares to start the legislative day. Pursuant to the House rules, the first item on the agenda is the prayer or invocation. But the Speaker warns the pastors that mentioning Jesus Christ has been banned by court order. In a Midwestern town, a teenage girl seeks an abortion. In truth, she knows very little about what that involves, but no one takes the time to explain the procedure or its lasting effects. This, despite a state law on the books for 7 years requiring doctors to inform patients of the realities and risk of abortions. But for 7 years, a judge has blocked that statute, even though similar laws have been found constitutional by a number of courts. The third story, a criminal defendant has been sentenced to 15 years in federal prison, but the judge has taken an unusual step, very unusual. He has unexpectedly prepared the record just in case an appeal for clemency is filed, a reprieve that the judge says he, quote, hopes will happen. The 32-year-old defendant has just pled guilty to videotaping his sexual activities with 2 girls ages 16 and 17. So what do these have in common? The link is David Hamilton, President Obama's nominee to the 7th Circuit Court of Appeals, who will probably be voted on next week. Judge Hamilton's record demonstrates an adherence to a liberal activist, not liberal. That's not a problem with me or Democratic lawyers who've been active in Democratic or liberal politics, but the question for our confirmation always is, I think, for the Republican members on our side, whether their personal political ideological views will overcome their commitment to the law. But Hamilton record, I think, is troubling, as I've just indicated. He worked for Acorn, was a litigation director for the Indiana ACLU. He has endorsed the notion that a judge's job is to, quote, write footnotes to the Constitution. I'm not sure they had a convention that he could participate in. Maybe he could write some of the Constitution. He has argued that judges, quote, need to empathize with the parties to better understand the effects of their rulings. And why did I mention Hamilton? Because Judge Hamilton was President Obama's symbolic first pick to the federal bench. And one White House official said that that nomination would, quote, set the tone for the future. I make these points to illustrate how much has changed since your last meeting here. Elections have consequences, and today we find ourselves, I think, at a legal crossroads. We are in a struggle to determine whether or not the classical Western tradition of law, one of the greatest achievements of all civilization, will continue to exist in the current form. No matter what people say of President Bush, it is indisputable that he nominated to the bench highly talented judges that are principled, competent, and faithful to the law. So they believed, as Alexander Hamilton described in Federalist 78, that judges must maintain an, quote, inflexible and uniform adherence to the rights of the Constitution. Leaders of the current administration, I fear, don't share that deep commitment to fair and objective decision-making.